Good morning, everyone. My name is Sarah Quinn Tran, and as Joseph explained, I'm the Head of Regional Policy and Public Affairs at IFRO. I'd like to extend my deep respect and greetings also to all the dignitaries in the room there today in Ghana, and my special thanks to Copy Ghana for inviting me to join you. I'm really delighted to be able to participate. So in my presentation today, I'm going to try to explore some of the impacts of new technologies on the publishing sector, and also look at how copyright and IP protections and policies can actually safeguard the rights of creators and creatives in the industry. So IFRO is a global umbrella organization for collective management organizations in the text and image sector. This is known as RROs. The IFRO community is comprised of both publisher and author representatives, and we have 154 member organizations across over 80 countries. And together, this represents many millions of text and image rights holders from all over the globe. IFRO is deeply committed to advocating for creators' rights and also to supporting good practice and progress for collective management frameworks all around the world. I wanted to take a moment here to highlight some of our activities in the African region. So IFRO's African Committee is a standing advisory body to the IFRO board, and it's currently comprised of 17 organizations drawn from 16 African countries. The African Committee is currently chaired by representatives from Malawi and Zambia, and also plays an important role in bringing members together to discuss issues of regional significance. Also at a regional level, IFRO has partnered with WIPO on 2 joint reprography projects in English and French-speaking Africa. And this is currently comprised of 26 participant organizations, including 9 non-IFRO members, and they're drawn from 26 African countries. The program offers targeted mentorship to support the development of viable text and image collective copyright licensing systems. And participants meet regularly online and also in person annually to discuss RRO best practice and also to look at their progress against tailored business plans. Our project consultant is jointly appointed by WIPO and IFRO, and Mr. Olaf Stockmo will be speaking later on this program. In addition to these overarching programs, IFRO also offers member support on areas of national interest. And indeed, as Joseph highlighted, we partnered with Copy Ghana over the last year. And this could also include advocacy on specific policy issues. We also work very closely with WIPO on the development of relevant resources and technical tools, including WIPO Connect and the WIPO CMO Toolkit. So some of you in the audience may not be too familiar with collective management and its importance to healthy publishing systems. And I thank the previous speaker for addressing this so beautifully in his presentation. To give an example, a concrete example of the role that collective management can play in fostering thriving publishing sectors, for example, in the past 5 years, COSAMA in Malawi has distributed over $1.8 million to rights holders. And between 2019 and 2023, as you can see on this flyer here, Copy Ghana distributed over $400,000 to rights holders. These funds flow directly to rights holders and also indirectly benefit many others involved in the creative industries, such as in-house writers and illustrators. Collective licensing revenue can play a really essential role in supporting the creation of works tailored to local needs and customs. On a more individual level, collectively managed rights are an important revenue source for authors, for individual authors, not just publishers. A study carried out in the UK found that 25% of authors receive more than 60% of their income from secondary uses. This study also found that for authors, a 20% reduction of the secondary licensing income would result in the equivalent of almost 3,000 fewer works being created annually. Olaf Stockmo is going to discuss this in more depth later on in the seminar, but essentially RROs exist to offer efficient and comprehensive licensing solutions that facilitate fair and remunerated access to quality materials, and this benefits users and creators alike. As we've heard from the previous speaker, the creative industries undoubtedly have important social impacts, such as promoting social cohesion, national identities, and crucially, to contributing to improved education standards. And beyond these very important social impacts, the economic implications of healthy creative ecosystems are substantial. As noted in the 2021 report for the OECD Culture Working Group, cultural and creative sectors are a significant source of jobs and income, and also generate very important spillovers to the wider economy. They are a critical driver of innovation and a source of creative skills that act as a magnet to help drive growth in other sectors such as tourism and also export. A 2022 UNESCO study shows that the creative industries contributes significantly to national GDP, with publishing the single most important sector in most countries. Creative industries are typically IP-intensive industries. The importance of IP protections and robust IP frameworks in fostering innovation in the development of sustainable IP ecosystems must not be understated. Indeed, this was really beautifully noted by the director of the Hong Kong Intellectual Property Department, Mr. David Wong, in his keynote speech at IFRA's Asia Pacific Committee meeting earlier this year. In observing that IP-intensive industries accounts for an extraordinary 32.7% of Hong Kong's GDP and 29.1% of total employment in Hong Kong, Mr. Wong emphasized the role of robust and agile IP frameworks in balancing the needs of users of IP products and rights holders, that is, IP owners and investors, in order to foster innovation. So here comes AI. Where can we begin? Well, let's start with some truly startling statistics. A recent PwC Global Intelligence report shows that AI could contribute up to 15 trillion US dollars to the global economy in 2030. And that's more than the current output of China and India combined. Of this, $6.6 trillion is likely to come from increased productivity, and $9.1 trillion is likely to come from consumption side effects. The greatest economic gains from AI are projected to be in China, with a 26% boost to GDP in 2030, and North America with a 14.5% boost. And this is the equivalent to a total of 10.7 trillion US dollars and accounts for almost 70% of the global economic impact of AI across two countries. According to OpenAI, ChatGPT acquired 1 million users in just 5 days after launching in November 2022. By comparison, it took Instagram approximately 2.5 months to reach 1 million downloads. And poor old Netflix had to wait around 3.5 years before it reached 1 million subscribers. Statistics from the World Intellectual Property Office indicate that while digital technology patent applications have grown across the board 170% faster than average over the past 5 years, AI growth is currently sitting at over 700%. Generative AI now accounts for more than 1/5 of all AI-related patents, and this number is rising very quickly. If you believe the hype, and gosh, there's really a lot of it out there, in terms of potential economic growth and consumer uptake, the opportunity of AI is enormous. However, with the rapid development of AI technology, it's also created a hugely unpredictable environment for creative industries. On the one hand, many in the creative sector are deploying generative AI as a tool to assist creative works. For instance, many publishers have already embraced AI technology to reduce administrative burden, to address workflow issues, to enhance efficiencies in the editorial process, for instance. On the other hand, however, it's also true that many are deeply concerned about the existential threat that AI, and particularly generative AI, may bring. So earlier this year, IFRA's member DAX, it's a visual arts collecting society in the UK, carried out a substantial survey of UK visual artists. And this survey revealed that 95% of artists feel they should be asked before their work is used to train AI models. 93% of the artists felt that they should be credited when their work was used to train AI. 94% of the respondents felt that they should be compensated financially when their work is used to train AI. And very importantly, the critical part, 96% stated that they had never given any permission for AI models to be trained using their work. Oops. The concerns of serious existential threat are not unfounded and can be understood from a number of perspectives. Firstly, there is the profound unfairness of the training processes. Soon after the advent of accessible generative AI tools such as Stable Diffusion, DALL-E, and Midjourney, creators were very quick, particularly in the visual arts sector, were very quick to call out concerns about their works being used to train AI without their permission and without pay. In exposing the Books 3 database in a series of articles for The Atlantic magazine throughout 2023, journalist Alex Reisner highlighted the rampant and unfettered use of unauthorized copyright materials in the training of generative AI models, all done without consent, without acknowledgement, or remuneration to any of the creators. There's also the issue of a total lack of transparency, not just on the input side, but also on the outputs. Generative AI tools are increasingly able to produce outputs or images that can look like photographs, illustrations, and other artworks that an average person may not be able to distinguish from works made by a human. Moreover, it's been demonstrated by many studies, and most notably by the 2024 Stanford University AI Index report, that generative AI tools very often produce exact replicas of copyright content, whether this is substantial chunks of text from novels like War and Peace, or whole scenes from movies, or copies of full images such as the one I'm going to show you on the next slide. Now, whether such output actually constitutes as copyright violations is obviously a central legal question that's currently before the courts. But the fact that generated content, generative AI content, can contain copyright material is, I think, indisputable at this point. Beyond these issues, there's also the issue of a complete lack of reliability in AI tools as they are currently standing. And this is noted in WIPO's AI Policy Toolkit, that while today's AI tools may be very good at summarizing texts or finding answers to frequently asked questions, they still have grave shortcomings. According to the WIPO toolkit, if a generative AI program is asked, for example, to produce a resume of a specific person, it is, and I quote, likely to generate a plausible-looking piece of text. In fact, it is likely to read so convincingly well that the reader is lured into thinking it is factual information. But the chances are that many of the entries, such as work placements or experience, are pure fiction. The program will simply have combined the words in the most likely statistical order without any real understanding. Very alarmingly, a recent study from Oxford University Press revealed that while 76% of researchers reported using AI tools in their research, only 27% reported having a good understanding of how to use these tools responsibly. Crucially, AI programs have no notion of truth, zero understanding of social norms, and absolutely no regard for ethical behavior. AI programs need substantial post-processing of their outputs in order to adhere to such norms. This image here, I'm hoping it will pop up soon. This image illustrates the point that was made, I referred to earlier in the 2024 Stanford University AI Index report. And that point was that generative AI tools can very often produce exact replicas of copyright content. And this image actually was featured in the South Korean government's Generative AI and Copyright Guide. And I think by using a Microsoft AI tool, employees of the Copyright Commission in South Korea actually put in prompts such as Snoopy and Winnie the Pooh. And as you can see, that AI tool produced Snoopy and Winnie the Pooh. So, creators and rights holders alike have filed very high profile lawsuits against technology companies who own or control generative AI models, claiming, for the most part, claiming mass copyright infringement. There are simply too many cases to discuss, and I won't be able to go into detail on individual cases here, but I have included a link on these slides, which I believe will be shared with the audience after the seminar. And this is a link there, we're under numerous lawsuits. There's a link to a site called ChatGPT is Eating the World. And it's actually just one example of numerous sites that are monitoring current cases before the courts. ChatGPT is Eating the World is very focused on the US, but there are a number of sites, and I'd encourage you all to have a look online. And whilst these court cases are still being heard, it's very clear that governments are increasingly alert to risks of AI being used. And I quote here from a Reuters article, to disrupt democratic processes, turbocharge fraud, and lead to dramatic job losses, amongst other harms. And governments are looking at regulation at an international, regional, and also national levels to ensure the ethical development of AI that promotes the well-being and safety of their citizens. Efforts from international bodies include things like the UN establishing the AI advisory body in recognition of the fact that rapid advancement of AI not only brings new opportunities to obtain or to achieve sustainable development goals, but also can pose very significant risks and challenges to achieving those goals. Earlier this year, the UN's General Assembly unanimously adopted a resolution calling for the development of AI as a good for all. And they noted that AI systems should help promote and protect human rights and shall be safe, secure, reliable, and trustworthy. WIPO has also published a new IP policy toolkit for regulators and IP officers to provide policymakers with a framework in order to understand the state of play with AI innovation right now, and also to encourage people to think about the future as AI becomes increasingly autonomous. The OECD recently, just in June, published a new report outlining 6 key policy considerations for AI data governance and privacy. And the OECD emphasized the importance of transparency, accountability, and security in all AI systems. At a regional level, the EU has been the absolute frontrunner in terms of legislative developments, with the EU AI Act coming into force actually just last week on the 1st of August. And the majority of its provisions will be enforceable from the 2nd of August in 2026. The EU AI Act is notable in its risk-based approach, which sets very clear requirements around restrictions of certain high-risk activities. And this includes things which I'm sure you've all read about, such as the biometric surveillance concerns. The EU AI Act, though, also obliges AI developers to provide transparency over what has been used to train AI models. And the text of the Act has largely been welcomed by the creative community, as it does go some way towards addressing creators and rights holder concerns. For those who are interested, I have included a link on this slide here to a position statement that many IFRO members have also signed. But the big question really remains, and the question is really whether these rules are going to be implemented in a meaningful and effective way. It's really essential from IFRO's perspective that generative AI providers are required to adhere to clear transparency standards in order to enable the effective exercise and enforcement of copyright. The EU response has been both lauded and also heavily criticised for being too prescriptive. By contrast, I just want to give another regional response here. The ASEAN AI guidelines represent a much more light touch approach, setting out 7 guiding principles aimed to help to ensure that trust in AI is fostered and that the design and development of and deployment of ethical AI systems is encouraged. And these principles include things like transparency and explainability, fairness and equity, security and safety, human centricity, privacy and data governance, as well as accountability and integrity, and robustness and reliability. They set out principles, but there's no sort of in-depth explanation of how those principles should be applied within those guidelines. At a national level, activity has been very high, but unfortunately, concrete responses at this point are quite thin on the ground, and that's understandably so as governments grapple with the complexities of the issue. Many jurisdictions, including those in the United Kingdom, Canada, Australia, New Zealand, South Korea, China, Vietnam, just to name a few, have carried out or will have initiated extensive public consultations in order to assess the path forward for the effective regulation of AI and generative AI. While some countries are considering following the EU model, others, notably the UK, have indicated that they're considering a softer approach to legislation or regulation, and they're urging players from across. They're urging players from across different sectors and industries to work towards a code of conduct on copyright and AI. Across many jurisdictions, TDM exceptions or text and data mining exceptions are increasingly under scrutiny. In the EU, as it stands, there are fairly clear parameters, and particularly clear parameters excluding commercial purposes, and there's also a provision for opt-out mechanisms. Importantly, and this is something I really wanted to highlight for this audience in particular, importantly, in the UK just last year, UK legislators opted not to introduce a very broad copyright exception for TDM after they carried out an impact assessment on the implications of the proposed changes. The proposed changes came from the UK Intellectual Property Office. And there was an impact assessment on and the assessment actually found that the impact on the creative industries would be significant. And I quote here from the report, it said that the UK Intellectual Property Office had taken insufficient account of the potential harm to the creative industries, and that also that while developing AI is very important, it should not be pursued at all costs. Other countries, notably Japan and Singapore, have also taken steps to clarify their existing TDM exceptions. And this is really in response to the proliferation of AI technologies that may potentially choose to rely on these exceptions as a defense to copyright infringement claims. I would highlight that the Japanese exception was introduced way back in 2017 or 2016. And in Singapore, it was in 2019 or 2020. So they've been in place for some time now and before the advent of AI as we currently know it. Very recently, the Hong Kong government has also announced a similar consultation focused on the TDM exception, and the IFRO Secretariat is in the process now of finalising our submission on that consultation process. There's also substantial interest, of course, in assessing TDM activity here in Africa, with WIPO conducting a pilot project on TDM to support research and innovation in universities and other research-oriented institutions. 3 countries have been identified for the pilot project so far, and those countries are Cote d'Ivoire, Egypt, and Ghana. The project is divided in 3 phases. The first is really aimed at mapping current treaty implementation and as well as the legal frameworks and licensing schemes that may exist in the region. And it's specifically looking at the use of TDM in research undertaken by universities and research-oriented institutions. In the second phase, based on the information and experiences collected through the mapping exercise, the project will work with 3 pilot universities in Africa with input from other regional stakeholders. And the intention is to develop case studies on the use of TDM in research. The idea is for lessons learned from the case studies to be then used to develop training materials on the effective use of TDM by universities and other research-oriented institutions in Africa. And these will be peer-reviewed by experts in the field. In the final phase, it's my understanding that what's envisioned is that the project will deliver 2 regional training seminars for a larger group of stakeholders. And at this stage, IFRO has assisted with WIPO's efforts to map the landscape of TDM tools and practices in Africa through consultation with our existing RO members. This consultation closed just last week on the 2nd of August. And based on the feedback we received, we understand that Mali, Togo, Cote d'Ivoire, and Niger already have national regulations and laws in place that facilitate TDM licensing. Additionally, we understand that Ghana is currently in the process of reforming its national copyright law, and we really hope, from IFRO's perspective, we hope to see that serious consideration will be given to including appropriate and not overly broad TDM provisions. Specifically in Cote d'Ivoire, I understand that our member Burita is drafting a new decree currently that will enable database producers to become members, and this will allow them to develop TDM licenses for universities and public research institutions. Butodra and BNDA in Togo and Niger, respectively, are currently awaiting legislative reforms before they can begin developing TDM licenses. So TDM exceptions, particularly in relation to AI development, they tend to be very closely tied with rhetoric around these fears of being left out of the innovation race. Whilst governments and policymakers are very understandably keen to ensure that their countries are competitive in the tech and innovation space, there are a couple of key considerations around governance that I wanted to call out here. Firstly, the Stanford University AI Index report, just from this year, highlights that robust and standardized evaluations for generative AI responsibility are seriously lacking. The research reveals a significant lack of standardization in responsible AI reporting. And what this means is that leading developers, including OpenAI and Google, primarily test their models against very different responsible AI benchmarks. And this practice really complicates any efforts to systematically compare the risks and limitations of all the leading AI models. Another very uncomfortable truth is that AI technology is currently in the hands, very concentrated hands, of a few tech companies, and those tech companies are spread across primarily 2 countries. And this raises some very significant concerns about potential use of market power, homogeneity, and perpetuation and embedding of biases. These can be unconscious or otherwise. A recent MIT review article indicates that, and I'll quote from it here, with vanishingly few exceptions, every startup, every new entrant, and even every new AI research lab is dependent on these firms. All rely on the computing infrastructure of Microsoft, Amazon, and Google to train their systems, and on those same firms' vast consumer market reach in order to deploy and sell their AI products. IFRO's position is that responsibly and fairly trained AI tools that use authoritative, trusted content and respect copyright laws and copyright owners will produce better outcomes for everyone, users and rights holders alike, and this is for several reasons. Cultural and creative sectors are crucial. They're the backbone to our society and to the economy. The European Parliament, in its 2020 resolution, emphasised the importance of human creators and highlighted that creating an environment conducive to creativity and innovation by encouraging the use of AI technologies by creators must not come at the expense of the interests of human creators. At IFRO, we firmly believe in this. Copies are undoubtedly being made in the generative AI training process, and copyright laws must be applied to the copying of protected works. These laws are very long established, and there's no reason why they should suddenly stop being applied now. It's our view that licensing is really the most efficient approach to bringing AI technologies and copyright together. Lawsuits and legislation will take some time, and it's very likely that not all of those lawsuits and pieces of legislation from all around the globe will actually reach the same conclusion. But licensing within a robust IP framework can help users and rights holders now by enabling copyright owners and users to agree on how to responsibly use copyrighted works. Both individual licenses as well and also collective management solutions are already widely available in a variety of markets, including text and image-based markets. As I highlighted earlier, IFRO has 154 members from over 80 countries around the globe. Collective licenses are particularly beneficial when there is a need to use materials from numerous rights holders, as is obviously the case with using works to train AI systems. And they can provide a fair way to protect authors and artists, publishers, and other rights holders, as well as facilitate access for users. Ultimately, IFRO holds that AI models should only be trained on legally obtained data sources, which are transparently reported, and rights holder opt-outs or opt-ins must be very fully supported, implemented, and respected across all jurisdictions. So as highlighted earlier, RROs exist to offer efficient and comprehensive licensing solutions. They exist to facilitate fair and remunerated access to quality materials and to benefit both users and creators alike. The landscape of text and image-based licensing is evolving very quickly, especially since the advent of AI. It was evolving quickly before anyway, but particularly with AI. And the need for efficient and transparent collective management mechanisms has never been clearer. RROs, with our extensive existing international networks, are very well positioned and indeed must adapt to the AI times. And I wanted to highlight here that in fact, RROs are already rising to the occasion. One of IFRO's members in North America, the Copyright Clearance Center, it's usually known as CCC, has already introduced a license for the reuse of content for AI, and this forms part of CCC's annual copyright license for businesses. The inclusion of AI reuse rights makes the annual copyright license the first ever collective licensing solution for the internal use of copyright materials in AI systems. And the license enables participating rights holders to fulfill the needs, to facilitate the needs of companies that require an efficient way of legally acquiring rights in order to use those copyright materials within their AI systems for internal use. Similar licensing solutions are also being developed in other countries, including in the UK, where another IFRO member, ALCS, is currently consulting with its author members on two possible AI licensing solutions that are currently in development by sister RRO, Copyright Licensing Agency, or CLA, in the UK. It's very clear from our perspective that licensing mechanisms, whether direct or collective, have existed for many, many years, and that solutions can evolve very quickly to be fit for purpose in these new AI times. I want to emphasize here, and I'm quoting from IFRO's president, Tracy Armstrong, it is absolutely possible to be pro-copyright and pro-AI. It is absolutely possible to be, and in fact, perfectly natural from my perspective, to be pro-human innovation, as well as pro-tech innovation. But creators' rights must be respected and AI must be used responsibly. When talking about AI, it's very easy to get caught up in hyperbole and tech jargon. So I wanted to close my presentation with this very salient quote from an author, Joanna Massajuska. I hope I pronounced that correctly. And she stated earlier this year, I want AI to do my laundry and dishes so that I can do art and writing, not for AI to do my art and writing so that I can do my laundry and dishes. Thank you so much for your attention, and I'm very happy to take questions now, or I think Joseph mentioned that the questions will take place at the end.